All right, so I cut myself off in the middle of my discussion of Hammer versus Sidway, which I was seeking to complete. Um, Again, we're on the topic of consideration. This is the 12th contract video in the series. In Hammer versus Sidway, we know that the grant of $5,000 to the nephew was treated by the trial court as a gift. And if to refresh your recollection, the nephew basically accepted the uncle's offer to refrain from certain vices until he reached the age of 21, and in exchange, he would get the $5,000. All right. The trial court says that that's more like a gift because the uncle isn't required to do anything. The uncle had received nothing, and the nephew had benefited from fulfilling the uncle's wishes. Well, the appeals court didn't think that that was the case, right? We've gone into a number of examples of, in the last video, of things that were not bargained for exchanges, right? But here, right, the promisee, who was William Story, the nephew, Jr., or the second, used tobacco, occasionally drank liquor, and had a legal right to do so. The court stated that the rights he abandoned for a period of years upon the strength of the promise of his uncle, the testator, William Story, that for such forbearance he would give him $5,000. They don't have to speculate on the effort which had been required to give up the use of stimulants. Right? We don't have to even ask whether the uncle got anything from Mr. Story. It's obvious that in fact he did get something. That thing was not money. He got his way. Right? He got his way. And that was something that he wanted. What he wanted was for the nephew to refrain, to forbear, right, from doing something. And we know one of the three prongs of a legally sufficient value, right? We have to have legally sufficient value and a bargain for exchange in order for a promise to be supported by consideration. And one of those prongs is refraining from an action that one has a legal right to undertake. That's known as forbearance. And in this case, the nephew forbore from carousing as he was entitled to do. There's nothing illegal about carousing, right? And so his forbearance from doing so is sufficient. It was bargained for by the uncle, and it's possessing a legally sufficient value as well. It's sufficient that he restricted his lawful freedom within certain prescribed limits upon the faith of his uncle's agreement. And so this case was decided more than 100 years ago at this point. It still contains the applicable principle. That's Hammer versus Sidway, that determines whether there is consideration present. All right? So when we talk about this quality of adequacy, we're sort of talking about a combination of, is there legally sufficient value and was it sort of bargained for, right? We're sort of mashing them together is one way to look at it. Another way to look at it is it's looking at how much consideration is given, right? But it's not constrained by whether the consideration that's given reflects the market value of the thing that it's exchanged for, right? If two things are exchanged that are of unequal value, then you would wonder, well, is this a fair deal? Well, the fair deal is the best deal that you can get. If I can get your car for $1, I will definitely try to negotiate to do so. Obviously, that's not the most common type of deal, but there are many transactions in which what is exchanged is not the fair market value. Now, just because it's not the fair market value does not mean that the deal is not fair. In fact, is it voluntarily consented to? If it's voluntarily consented to, then the law will take the view that that thing is the thing that the parties wanted, the offeror and the offeree. So the court won't question the market value of the thing unless it is, meaning the market value of the consideration, the market value of the exchange, the monetary value of that exchange becomes irrelevant unless it indicates that there is a lack of voluntary consent. And I know that that's not the easiest case, right? But when there are cases where voluntary consent might be lacking, that causes the court to look more closely at the bargain. How do you allege that there's no voluntary consent? Your Honor, my client was under duress, meaning that they were basically placed in an inappropriate position by the other party, and as a result, they were forced, basically coerced. Duress is like a type of coercion, coerced into making that deal. That's one example, all right? Now we'll move on to talk about agreements that on their face actually lack consideration. But simply keep in mind that duress, fraud, and undue influence are each things that may indicate that there is not voluntary consent. Duress, fraud, and undue influence. Now, for the types of things that cannot be consideration, right? When we talked about what is consideration, we talked about doing something that you don't have a legal responsibility to do, agreeing to undertake an action that you have no prior obligation to undertake, and also forbearance, right? That kind of defines the things that are consideration, and then counterpoint to that are a number of things that are not consideration because they don't fit into those definitions, and we can categorize those things, all right? So number one is a pre-existing duty. In most circumstances, a promise to do what you're already sort of under legal obligation to do is not consideration, all right? So a company begins a 7-story office building, right? After 3 months, they demand an extra $75,000 on the contract. And they say if the $75,000 is not paid, the firm will stop working on the project, right? If there is no other extenuating circumstance, a promise to pay that additional $75,000 is not enforceable because there's no consideration. You're already under an obligation to complete the building for $75,000 less, right? Now, that there are some exceptions to this, right? Let's suppose we're constructing the office building and we run into unforeseen difficulties, right? Unforeseen difficulties is an exception to the pre-existing duty rule, but you can't have extortion, right? You can't hold somebody up, right? Saying, we're not going to complete this unless you give us $75,000 more. That's extortion. You're under existing duty to do that. But let's suppose there were unanticipated and unanticipatable cost overruns on the project. For example, your original siding became unavailable. Manufacturer goes out of business, right? You're only able to obtain siding from another manufacturer, and it's considerably higher quality and more expensive, right? That's an unforeseen difficulty. Unless you had a crystal ball or otherwise foreknew that your supplier was going to go out of business, you couldn't have known that this was going to cost an additional $75,000 to get the client the result they want, right? And if it's an unforeseen difficulty, say you're doing construction and you encounter an additional rock formation that no one knew existed on the property, right? That, or the suppliers going out of business, things like that could, in fact, justify new consideration in the amount of $75,000. Also, in some cases, the law will allow you to engage in a rescission. Rescission means that both parties agree to unmake a contract, right, so that the parties can then make a new contract. This rescission and creation of a new contract at the same time often makes it difficult for some courts to accept that rescission as a new contract if one of the parties simply doesn't want to perform under the new contract. If they find a pre-existing duty, then the new contract is invalid because there's no consideration. There are ways around this. The parties, for example, may agree in writing that this contract may be amended in a writing signed by or assented to by both of the parties. All right? This means that the new consideration, if it's agreed to by both parties, is not it's not, it doesn't fail for lack of consideration. It is simply an amendment in accordance with the terms of the original contract. All right. So again, that brings us. We've dealt with pre-existing duty. The next category is past consideration. Right. I think in the case where you give me I think I mentioned in the last segment, you give me a gift of an antique, right? And then I decide to give you money for it. That's known as past consideration. It's based on events that have already taken place, which means it can't be what? Bargain for exchange. Remember, the two parts are legally sufficient value and bargain for exchange. In that case, the bargain for exchange is missing, and that is the case with all past considerations. So here's an example. Jamel Blackman became friends with Allen Iverson when Iverson was a high school student who showed tremendous promise as an athlete. Blackman suggested that Iverson use the answer as a nickname in league tournaments, and said that Allen Iverson said that he would give Blackman 25% of any proceeds from the merchandising of products that use the answer as logo or slogan. Because Iverson's promise was made in return for past consideration, Blackman's earlier suggestion, it was unenforceable. It was simply a gratuitous gift by Iverson. In effect, Iverson stated his intention to give Blackman a gift of 25% of any merchandising revenue that uses the answer, but again, that can be withdrawn at any time because it is simply a gift rather than consideration. Answer the prompt below and you can move on to the next video.